Therefore, as far as the measures having equivalent effect are concerned, in cases, the Court of Justice, as we stated, provided for a new concept as mandatory requirements, and there are good reasons, as we stated, put forward by the member states to justify their conduct. According to the court, the mandatory requirements must be unrelated with the origins of the product and must serve objectives considered by the court as legitimate. The Court of Justice accepted the following list of mandatory requirements, but this is not a closed list. For example, protection of public health, protection of environment, protection of working conditions, fairness of commercial transactions, protection of fundamental rights, and preservation of maintenance of order in society. Therefore, where there exists an indistinctly applicable measure, we have to consider whether there exists one of the mandatory requirements as provided by cases or one of Article 36 derogations. We may save the member state either by Article 36 derogations or by mandatory requirements as provided in cases by the Court of Justice. This only applies, this distinction or this possibility of saving a member state by mandatory requirements is only possible for indistinctly applicable measures and not by distinctly applicable measures, and cases is the main decision of the Court of Justice on the indistinctly applicable measures. Therefore, so far, we have mentioned Dassonville as a very important decision of the Court of Justice for indistinctly applicable measures. Now we have mentioned cases for the mandatory requirements, where the court has provided rules on mandatory requirements, and there's a third landmark decision. There will be a presentation about that decision as well, which is the Keck Judgment of 1993. This is also about indistinctly applicable measures, where the court drew a distinction on selling arrangements, satış düzenlemeleri. According to that decision, certain indistinctly applicable measures, namely the selling arrangements, are never covered by Article 34 and are independent from mandatory requirements. In Keck, therefore, the court used a distinction between product requirements and certain selling arrangements. regarding product requirements, the court reaffirmed its decision in Cassis. And it said, according to product requirements, as regards product requirements, the rules in Cassis shall continue to apply. The product requirements are the rules which relate to the goods themselves in terms of their packaging, size, or composition. Certain selling arrangements, on the other hand, do not hinder the trade between the member states within the meaning of Dassonville formula. According to the Keck Judgment of the Court of Justice, certain selling arrangements do not hinder the trade between the member states directly or indirectly, or actually or potentially within the meaning of Dassonville formula, if the following two conditions are satisfied. The first requirement is that the provisions on certain selling arrangements must apply to all affected traders within the territory, and second, they must affect in the same manner. The marketing of domestic products and the foreign products. Therefore, according to the Keck Judgment, if these two conditions are met, then we speak about certain selling arrangements which will not be considered as quantitative restrictions and distinctly and indistinctly applicable measures, where there exist certain selling arrangements, unlike quantitative restrictions and measures having equivalent effect, they do not breach Article 34. However, the problem with the Keck Judgment was that the court did not define or did not state or did not list the certain selling arrangements. Right after Keck, the court found out certain marketing circumstances which would be called as selling arrangements within the meaning of Keck. For example, the national rules on the times and places of the goods to be sold. The national rules on the times and the places at which the goods could be sold. For instance, the Sunday trading rules. Sunday trading rules, meaning Sunday trading rule? No, Sunday? Sunday? Exactly. The national rules which prohibit trade on Sundays. Sunday trading rules. The national rules which prohibits or which requires the shops to be closed on Sunday. According to the Court of Justice, this is a selling arrangement. Therefore, such a requirement does not or is not considered as a measure having equivalent effect. Therefore, does not breach Article 34. Another example is that the national rules requiring petrol stations to close at night. The national rules requiring petrol stations to close at night did not breach Article 34. Or, for instance, the national rules prohibiting selling in private homes. The national rules prohibiting selling in private homes are considered as national rules on the times and places at which goods to be sold and under the heading of selling arrangements. Another example of selling arrangement as decided by the Court of Justice is restrictions on advertising. For instance, a French rule which prohibited the fuel distribution companies from advertising on TV. A French rule which prohibited the fuel distribution companies or sector from advertising on TV. Or restrictions on outlets are also considered as selling arrangements. In a decision of Karner, the Court of Justice summarized its case law on certain selling arrangements. According to the court, provisions concerning inter alia in Turkish diğerlerinin yanı sıra the national rules concerning inter alia, the place and times of sale of certain products, advertising of those products, as well as certain marketing methods are considered as selling arrangements or are considered as provisions on certain selling arrangements within the meaning of Keck. Okay, any questions so far? Who will be presenting Kasus? Deniz and Öykü. Who will be presenting Keck? Okay, you will have literature in Turkish as well in the book I have just given. All right? Das Onvil? No. Okay. Any questions so far? Yes.
In the distinct applicable measures and equivalent effect, can you say the person with proportionality principle?
It has to be, yes, proportional as well. Proportionality applies for every aspect. All right? Please read from the chapters and then come back if you have further questions. The last topic would be about prohibition of non-tariff barriers on exports. It will be very short, as I said. For the exports, again, quantitative restrictions are prohibited. And they include total bans, quotas, etc. There is no question today about quantitative restrictions. A famous decision about this aspect was in 1992, Delhaize's decision of the Court of Justice, where a Belgian company, Delhaize, ordered 3,000 hectoliters of wine from Spain. Contrary to Spanish rules, which limited the amount of wine available for other member states. The Court of Justice said that the Spanish rules breach Article 35 because there was a limitation on the export of the goods to other member states. Article 35 also prohibits distinctly applicable measures. Distinctly applicable measures having equivalent effect. For example, Article 35 prohibits national rules imposing conditions on exports which are not applied to domestic products. Distinctly applicable measures which are applied only on exports and not applied on the domestic products are prohibited by Article 35. In the case of the Court of Justice as well, a national rule, for example, providing for a license for exported goods was found in breach of Article 35. According to the case law of the Court of Justice, indistinctly applicable measures and selling arrangements are not covered by Article 35. Therefore, indistinctly applicable measures and selling arrangements are not covered by Article 35. Therefore, as far as exports are concerned, this part shall not be applied, okay? Only distinctly applicable measures having equivalent effect are covered by Article 35. And both quantitative measures and measures having equivalent effect, both quantitative measures and measures having equivalent effect on exports may be justified according to Article 36 derogations. They may be justified according to Article 36 derogations. All right, any questions? We can make a discussion once you read and come back, all right?